Good afternoon, everyone. I'm very happy to be here, and today I'll talk to you about the coming changes to our copyright law here in Poland, caused by implementing the so-called Digital Single Market Directive. My name is Kamil, and I am attorney at law and senior associate at MELD Jodłowski-Szczawiński, partnerzy radcowie prawni i adwokaci. Among other things, I'm responsible for our intellectual property practice with special focus on the video game industry. During my presentation, we will go through a short history of the legislation. Then I will present changes that I think should interest the video games industry, and I will end my speech with conclusions and some tips on how to prepare for them. So let's start with that brief history of the legislation. The European Parliament Directive on Copyright and Related Rights in the Digital Single Market was adopted by the European Parliament and the Council of the EU on April 17, 2019. According to its provisions, it must be implemented by the Member States before June 7, 2021. Among many reasons for drafting and then adopting this law, the will to harmonize copyright in the European Union, at least provide some minimal harmonization, was one of them. As we speak, 22 countries have implemented the DSM directive and the rest have not. Oh, I'm sorry. So, Poland is not alone in this issue, but the group of latecomers gets smaller and smaller. Because of those latecomers, instead of further harmonization of copyright in EU, we have not only jurisdiction with different implementation of this directive, but also countries without it. In general, such situation is not good for any industry, and for lawyers, it gives us no certainty and complicate trans-border matters. Poland is one of the countries that still don't transpose the DSM directive, but our legislative process in this area is underway. Initially, the implementation was delayed by a legal challenge before the Court of Justice of the European Union. The challenge regarded Article 17 of the DSM directive, about which we won't talk today because it's out of the scope of this presentation, but in short, we lost. At the moment, the government bill is almost final and the draft is available for public consultation. Probably after summer or in last quarter of this year, we'll see the final draft submitted to the parliament for further legislation. It is hard to predict when and what changes, if any, will be made to this draft, while it is being discussed in the parliament. So I will not even try to add anything and say anything on this matter, but please keep in mind that some things may change on the way. The scope of the DSM directive has been widely debated in the EU as it touches on some controversial issues. The drafting and adoption of this directive received a lot of media attention at the time and again locally when countries transposed it into their laws. However, most of, if not all, of those controversies were caused by provisions that are not topic of my presentation, so I'm not going to discuss them also. But probably these controversies are one of the reasons why other provisions did not get as much attention. So what is important for the game industry? The most important changes that will have an impact on conducting business in video games are in the implementation to Polish law articles from 18 to 23 of the DSM directive. These articles provide some adjustments and additions to our law, which in the opinion of the EU should improve the weaker contractual position of authors and performers. These changes will affect the different degree the scope of obligation in such areas as remuneration, transparency, right of revocation. So let's start with a principle of appropriate and proportionate remuneration. I think we can all agree that remuneration of authors and performers for their work should be fair and proportionate to the actual or potential value of the rights licensed or transferred. DSM directive states that the remuneration of authors and performers should be appropriate and proportionate to the actual or potential economic value of the licensed or transferred rights. In general, authors and performers are usually the weaker contractual side and also may not be able to correctly assess economic value of their rights. So this regulation aims to give them tools and even out their situation. But what does appropriate and proportionate mean? Market gives us some hints about appropriate. In this regard, the easiest way to properly value someone's work is to look at what others are paying or are willing to pay for something similar or the same. Now, that the labor market is truly global, especially when it comes to industries such as video games, the struggle to retain or attract new team members faces a lot of competition, not only locally but globally. So the salary offered, which usually includes compensation for the transfer of copyrights, is in general market-driven. So I don't, oh, sorry. It's not all in this slide. So the salary offered, which usually includes compensation for the transfer of copyrights, is in general market-driven. So I don't think it's a challenge, at least in my opinion, to make sure that the remuneration for the author or performer is appropriate. But what about proportional? The remuneration should take into account the author's contribution to the overall work, which means not only a percentage share in the final work, which will translate into lump sum remuneration, but also market practice in the field and the actual exploitation of the work. The EU legislator emphasizes in the recitals of the DSM directive that the lump sum payment might also be considered as an appropriate and proportionate remuneration, but it should not be the rule. But this view is not transposed to our law and is considered more as a hint to member states how to implement the directive in this subject. But what if the author or both parties to the contract didn't foresee the success of the game? Here the EU legislator sees the need for a mechanism that entitles authors to claim additional appropriate and fair remuneration from the other party, in our case, the game dev studio. If the remuneration originally agreed by parties turns out to be disproportionately low compared to the revenues derived from the exploitation of the end product, a contractual adjustment mechanism is nothing new in our jurisdiction. Better known as a bestseller clause, its purpose is to give the author tool when his or her work turns out to have a much higher economic value than the author or both parties could assess in the moment of concluding the agreement. The idea is that this mechanism will work in conjunction with the transparency obligation by giving authors a mechanism to use the information received from the user of the rights regarding the exploitation of their works and revenues generated by them. So, how it is right now? Currently, there are 3 articles in Polish Act concerning the remuneration of an author that interests us in this matter. Article 17 and Article 43 and 44. I'm not going to go into details because it is nothing new, so in short, currently, the Polish Copyright Act states that unless it is clearly stated that the transfer of rights or license is granted free of charge, the author is entitled to remuneration. This remuneration is if not specified in the agreement, shall be determined taking into account the scope of the right granted and benefits derived from the use of the work. If there is a gross disproportion between the remuneration of the author and the benefits obtained by the purchaser of the economic rights of the author or the licensee, the author may request the court to increase the remuneration accordingly. At present, our bestseller clause is not commonly used as a basis for claims, at least in court proceedings. In one of the popular legal databases in Poland, we'll find only 3 or 4 judgments in civil cases, with claims based on Article 44. The use of this mechanism seems to be simple from a formal point of view. The author must sue the acquirer of user of the rights. However, as simple as it may seem from this perspective, authors are reluctant to use this tool. Why? I don't know. Maybe I don't know about any research in why in Poland the use of bestseller clause is not popular. But usually I come across opinions that the reasons are culturally determined. In jurisdiction where authors' position was never strong, authors are more reluctant to assert their rights in this matter. Or there is no strong views that authors currently are not sufficiently remunerated, even among authors. Or maybe fear of being blacklisted or marked as troublesome in industry. Another thing is that the claim must be well documented, and even then, the plaintiff may not be sure about the outcome of the lawsuit. The uncertainty of the outcome and the risk of labeling in the industry makes this clause not so popular in my opinion. In industries where struggle for worker is global, there may be the feeling that the proposed remuneration are sufficient, but such cases happens from time to time. We all know the case of Mr. Sapkowski and CD Projekt, for example. And right now, something about transparency obligation. The transparency obligation is designed to force publishers to be more transparent with authors by requiring them to provide information about the exploitation of their works and the revenues generated. Its scope is broad and applies not only to authors who are paid on commission basis, but also to those who are paid on the flat fee basis. Lump sum, for example, remuneration. Yeah? The transparency obligation is not new in our legislation. However, at the moment, such obligation is guaranteed by Article 47 of the copyright law and refers only to situations where, on the basis of the contract, the remuneration of the author or performer depends on the amount of proceeds from the use of the work or performance. This kind of remuneration is not used in general within teams standing behind the games, but it happens. When I come across such remuneration, it is mostly for book comic authors whose ideas served as the basis for the game's plot or world. In such cases, it is not a big problem to fulfill such obligations to authors. Usually, these kinds of contracts are clear about the amount that should serve as a basis for remuneration and the method of verification. So, there is no need to use statutory provisions. The provisions of the DSM directive regarding the transparency obligation may be problematic, especially at the beginning, for the game dev studios, because when implemented, their scope will cover not only persons paid by commissions, but all team members with some exclusions. This may be the biggest change and challenge for the game dev studios, which are not used to commissions. For publishers who are used to reporting their revenues to their licensors for calculation of their remuneration, it may sound not so revolutionary. Information provided to authors and performers should be up to date to allow access to the latest data, relevant to the exploitation of the work or performance, comprehensive in such a way that it covers all the sources of revenue that are relevant to the exploitation of the work or performance. Only those who have acquired the material rights or license from the authors will be required to provide such information. However, the information should also include data on exploitation of the work by other further acquirers or licensees. If the initial acquirer doesn't have access to such data, it should provide the author with the identity of these entities. In this situation, the obligation of transparency falls on those other entities. The information should only cover the use of the author's work, not the entire final product of which the work is a part. However, it may be difficult to keep information about the final product from the authors because we'll probably provide them with information about what part of the game is their work. Not all game development studios are publicly traded, so some of them may be interested in keeping some information about the distribution of the game confidential. It may be a good idea for them to review or implement appropriate provisions in the NDAs with authors, requiring them to maintain confidentiality on this subject. Also, the information should be provided on a regular basis. adequate to the specifics of the given industry and the use of the work. However, not less than once a year and not more often than once a quarter. So, in the end, the problem stays the same as in the current regulation regarding authors who are entitled to commission. The scope of documents or data that they are entitled to get. Like now, in Article 47, the scope of the information that can be requested is only functionally defined in the law as information that is relevant in determining the amount of compensation. So what happens if obliged person will not fulfill its transparency obligation? It depends on the author determination. Because drafted bills do not provide any statutory penalties in this matter. In order to obtain information and receive documents, the author probably must demonstrate to the court the necessity of obtaining certain information and documents, which must be evaluated in the context of the claims being asserted. Currently, the draft law provides that this obligation will come into force 6 months after the date of publication of the bill. It is important to note that the transparency obligation will apply to the exploitation of works from the date of entry into force of this provision. So, our legislator is giving us a lot of time to adapt to the new obligations. So, about exempts. Excluded from the right to information under the obligation of transparency are authors whose creative contribution to the overall work is not significant unless the author requesting the information demonstrates that the information is necessary for him or her to exercise the bestseller clause. Agreements on the use of works concluded with a collective management organization, which I don't know any CMOs here in game dev industries, so it shall not happen. A royalty-free license granted by the author to the general public, and works of employees. The obligated party will also have the right in justified cases where the cost or administrative burden of implementing the transparency obligation would prove to be disproportionately burdensome for them, to limit its obligation to the forms and scope of information that can be reasonably be expected. What is important? In the case of a collective work, a collection of works and a joint work, it is presumed that the creative contribution is not significant in relation to the whole work. However, in the case of an audiovisual work, this presumption doesn't apply to the director, the cinematographer, the author of an adaptation of a literary work, the author of musical or spoken works created for an audiovisual work. Also, the Minister of Culture and National Heritage may also determine the frequency or scope of the information to be provided for specific sectors, uses, or types of works, if market need arises. So, here are, I prepared a very simple graphic that should show how the process of the creation and distribution of the game looks like, and what kind of works, authors it involves. Yeah, it's very simple, so. Here, let's look now at how exclusion can influence the new obligations when it comes to the game. So, the game is not just a single work. It consists of the works of many authors, often open source or licensed material. So in this matter, without going into legal details of what the game is in terms of our law, we can say that it's either a collective work, a collection of works, or joint work built by many authors and many independent or not works. And so we have the, in this matter, we have a presumption that the creative contribution of the authors to the overall work is not substantial. So at least until one of the authors proves to us that their contribution is not substantial, or that they need information because they want to use the bestseller clause, we will not have a transparency obligation. Nor we will have any obligation of transparency in the case of employees' works. Also, a lot of the works that make up the game are computer programs. In their case, there is no transparency obligation, regardless of whether the contribution is significant or the status of the author. Let's look at this relation. We have two groups of workers, employees and self-employed contractors. Both groups create works that are not computer programs, but are essential for the game. Graphics, sound effects, dialogues, etc. Because all of their work is part of the game and will not be distributed otherwise, regulation gives us presumption that all of their work is not significant in relation to the game as a whole. Probably not everyone will agree with that. Also, employees' work is exempt from transparency obligation regardless of whether the work represents significant contribution to the game or not. However, our self-employed contractor may still require us, game dev studio, to provide him with information for the purpose of claim based on the bestseller clause, or present that the presumption is baseless and his work is significant contribution to the game. So he's entitled to receive on a regular basis data on exploitation and profits from his work. Here we have an easy case. We have two bases for the exemptions. In case of employee, because his work is in the scope of his employee contracts, producent game dev studio will not be obliged to provide him with any information regarding exploitation of his work. In case of both employee and self-employed contractor, because computer program. Here, I believe things may start to be a little tricky. We have authors whose work are not included in the game itself or are its part, but are also distributed independently. As long they are part of the game, in my opinion, with current wording of proposed law, we will have the presumption that their contribution to the game is not significant. However, if they are distributed separately from the game, we will not have such presumption unless this work will be co-authored itself, and we'll need to look for another reason to limit our transparency obligation or just met our obligation and give them data. Here we have a similar situation. It is not so uncommon that the publisher reserves the rights to create and distribute the merchandise, so publisher also has to take into consideration the transparency obligation. And here we have the situation where publisher is the further user of the rights, so the game dev studio should also include data that it has from the publisher, or if not, provide the author with information who is the publisher, and they may request such information from the publisher directly. So that's all about transparency obligation. Now something about disputes. The EU legislator sees that there is a certain reluctance of authors and performers in their relations with acquirers and users of their rights, especially when it comes to court proceedings. Therefore, Article 21 states that the member states shall provide that disputes concerning the transparency obligation and the contractual adjustment mechanism may be submitted to the alternative dispute resolution procedures. However, the article doesn't provide any details of that procedure. This means that member states have freedom of choosing how to implement this provision. And in Poland, in drafted bill, we see that our legislator plans to transpose this article using minimum resources and use for that the existing mediation in civil proceedings. How it is right now? Currently, under the Code of Civil Procedure, in all civil cases, including those involving intellectual property, parties may decide to submit their case to mediation conducted by the certified mediator. There is no specialized body or procedure outside the civil process. I leave aside here the question of how the parties themselves may determine the dispute resolution in their contracts, where they can decide that they will use out-of-the-court arbitration. How it will be? The authors of the new plan new law plan to use the mechanism already existing in Polish law, judicial mediation, which is regulated in the Code of Civil Procedure. In the opinion of the authors, this mechanism meets the criteria set in the Article 21 of the DSM directive, and taking into account the fact that the disputing parties can already use this procedure in their dispute, this provision doesn't change anything, and its sense is more informative and redundant. Right of revocation. Right of revocation is the safety valve for authors and who transport rights or license them on third party and that party fails to exploit them. This is also nothing new in our law, but EU legislator decided that it also should be a subject of harmonization within the EU. How it is right now? Right of revocation already exists in Polish law under the Article 57 of copyright law. However, the scope of Article 22 of the DSM directive seems to be narrower. Right now, authors are allowed to terminate or cancel the agreement of transfer of rights or license, no matter whether the license is exclusive or non-exclusive, under the condition that their work after the agreed time, or 2 years if such time was not set in the agreement, is not exploited. Next to this right, authors are also entitled to damages, or instead they may claim double remuneration as liquidated damages if the lack of exploitation is due to circumstances for which the acquirer of the rights is responsible. How it will be? The draft proposes that the national regulation will be limited to the scope indicated in the DSM directive. So, the right of revocation will only be available in the event of transfer of rights or exclusive license. No such right for non-exclusive license. The second change is to eliminate the claim for damages or liquidated damages. It doesn't mean that authors will not be entitled to damages in the event of breach of contract by the acquirer of rights. They still have such claim, but under the general rules of the Civil Code. However, no statutory liquidated damages. Also, authors gain a new right to transform the exclusive license to non-exclusive license instead of terminating the agreement. Furthermore, no right of revocation for co-authors whose work cannot be exploited independently or in the event of lack of exploitation is caused by the author himself. What to do? Game Dev Studio should address this issue the same way as right now. So all these current solutions for this clause will be still valid. For example, setting the save date for first exploitation of the work in the contract may be the best idea. While the changes may not seem revolutionary or as far-reaching as those for the press and information portals, some may seem difficult to manage. Experienced game dev studios are aware of how the resources are used in each project and already need to properly evaluate what each member or employee's work is worth. I believe that the remuneration received by the author will probably be the main and decisive factor in deciding what part of the final work can be assigned to the particular author. As for the transparency requirement, I think it may be the biggest change to deal with. The compliance may require a lot of work at the beginning. It is hard to say right now how these reports should look like, but it seems that the industry has a lot of puzzles already in place. Looking at the proposed exclusions, I believe that most of the game dev studios can mitigate almost whole risk and in most cases stay without additional obligations. So basically, we can say that when it comes to the game itself, there may not be much to do. However, every game dev studio or publisher should consider that some authors may ask for such information and be prepared for such situation. Regarding the right of withdrawal or revocation, I do not see any changes that would cause game dev studios to be more concerned than they are now. So how to prepare? Go through used contracts templates, employee contracts, check whether the scope of the agreement covers works done by the employee. Civil contracts or B2B, check whether the scope of the works are covered by exemptions from transparency obligation. And contracts governed by foreign law, check whether in given jurisdiction you are not already subject of some obligations that we were talking about. Prepare templates of reports for transparency obligation and address the transparency obligation in NDAs. And that's all from me. Thank you very much. And are there any questions? No? So, great. Thank you for your time.
Okay, thank you.